This will be the People News. All right. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. All right. Use your Second Amendment right. Arm yourself with knowledge. Okay. Quit going by hearsay. Always question things and look at definitions of words. Because what they use is not what you use. All right. Let's see here. What else do I got to say? Anything I say or do not take it as legal advice. Okay, this is education only. All right, and it's only in my opinion. Just take it with a grain of salt. Okay, and well, number one, salt's cheap. All right, don't have fancy stuff, y'all. This is my bedroom TV. It's my cheap little cell phone. All right, this is what I have. This is what I'm gonna deal with, and I'm sorry for any non-fancy stuff. Okay, I'm not James Freeman. Let's go.
Continue that part of it and give you some time so that you can have your motions be heard prior to arraignment, if that's what you would rather do.
Well,
And the court is still standing there, which I appreciate, but you're excused, Mr. Cook, at this point.
just quickly, I ended up over finding the competency with Mr. Coker. Mr. Coker was concerned about Simon's getting evidence.
Okay, yeah, thank you.
Could would the court provide me with a pencil or pen for the duration of the hearing?
So let me ask, I asked the jail about security issues, which that potentially is, but you're looking to take notes of what's going on?
Yes, I just want to scribble on my scrap paper, please.
Okay, I understand.
I'm at absolute pass.
Just sit and think about that. The court's got to ask for the jailer for pen and paper to write down information that's the process going through court. If the bailiff decides not, or not to let him because of hazards or whatever, I kind of understand that, but at the same time, he needs to write these things down. If he's denied these things, so should the prosecutor, right? That's unfair advantage, and that's one-sided. Okay, that's conflict of interest. Be honest with you. All right, you're letting one side do something, and yet not let the other side do something. Conflict of interest, right there. Okay.
I'll get back to you.
You okay? Sure. Yep.
So it sounds like the court's giving me a binary choice. While I don't, while I would note my objection to any continuance and tolling of my right to speedy trial days, the most important thing is that the court recognizes that these dispositive issues should be heard before the prosecution attempts to arraign me. So if those are the only two choices and the court's noted my objections, then I would say let's set a motions hearing prior to arraignment.
You wanted to do well. I guess we can do a couple different things. I'm not trying to make it either or. We can have arraignment, have you note your objections, preserve your objections, but at least start the speedy trial clock if that's what you want to do, and then have the motions heard at another time. Or we can just wait to hear the motions fully fleshed out at another time and then arraign some point after that. I'm not asking you to waive any of your rights if you're looking to sort of start things.
Thank you for the clarification, Your Honor. My preference would be to note objections for the record today and set a hearing at the earliest possible date for my dispositive motions to be heard. And if the court has not disposed of all of the charges at that hearing, then of course the prosecution would be afforded the opportunity to attempt to proceed with arraignment.
Okay. All right. Do you want to do the arraignment first, or do you want to note your objections for it, and then, regardless, I'm going to make sure that you preserve your rights to it, and then we'll hear them sort of fully at some point later.
Oh, so maybe I misunderstood you. I thought what we discussed was the option where today I note my objections and we schedule for a later date at the court's earliest possible convenience the hearing of my motions to dismiss, at which time the prosecution would also seek arraignment. Because my position is that we don't get to go to arraignment when my dispositive motions have yet to be heard, because the prosecution does not even have probable cause.
No, I understand what you're saying with that. What I'm trying to, it sounds like you want to start the speedy trial clock today,
If possible.
which it started with arraignment.
Then
And you want to preserve all your rights with that. And so I'm trying to do both of that for you, is for you to note your objections, do the arraignment, you preserve your rights for all of that, and then set it at a time. That would start the speedy trial clock, and then we can set a time to be able to hear everything more fully.
Right, so I recognize the court's position on that. And I would just have an additional objection to note for the record, which is that I object to the fact that I'm still being incarcerated without probable cause, and that the speedy trial clock would toll until the motions hearing is set. But I'm going to stick to my position that arraignment cannot happen until after my motions to dismiss are heard.
Okay. So what I'm gonna ask is for Mr. Lavin to do the arraignment. I'm gonna allow you to preserve all that objection, and while that's happening, I'm gonna ask my bailiff to set a time to be able to hear your dispositive motions completely. I've got that you were objecting based on probable cause. And is there another one that you wanted to note at this time?
There's several, Your Honor.
Okay.
So in no particular order, the prosecution is violating the fruits of the poisonous tree doctrine, because all of these alleged EV violations.
And I don't have time to sort of hear it all, but just fruits of the poisonous tree, that's enough. I understand what that means. So,
Okay, so it's clear for the
I'm
record.
gonna stop right there. Right, we're paying her. She has time. I understand she has other court cases. No, we're paying her to do her job correctly, not to go rushing through everything. She's to take everything within reason, and within standing, and within the four corners. And that's what we're paying her to do. And rushing him through this is not okay. Period. People, this is your tax dollars.
That relates to King County Superior Court case number 21-5-00680-6, in which the prosecution star witness perjured herself in collateral and extrinsic fraud to fraudulently obtain a restraining order to conceal the kidnapping of my son perpetrated by Jessica Ray Owen, date of birth 11/23/1975, and Magali Elizabeth Berman, date of birth 1/31/1986. Secondly, we've got a violation of the priority of action doctrine, which the prosecution may wish to look at the Stevens County District Court out of the Division 1 of the Washington Court of Appeals. I believe that's 2019, which states that once one court has, quote, when one court exercises its jurisdiction, the priority of action doctrine prohibits another court from interfering, unquote. What the problem that the prosecution has is that it's attempting to violate the double jeopardy clause of the Fifth Amendment of the United States Constitution, as well as Article 1, Section 9 of the Washington Constitution, by prosecuting me for the same alleged criminal law violations as City of Seattle was across its 10 cases. I would like to inform the court for the record that today one of my friends was able to file a petition for habeas corpus under 28 United States Code Section 2241 in the U.S. District Court for the Western District of Washington, case number 2:CB-0110-JLR-SKB, although for the record, SKB will be removed shortly because I filed a LCR 73 motion stating that I do not agree to having the magistrate judge preside over that case. And the court should further be aware of the fact that the lawsuit United States v. City of Seattle that was initiated in 2012 by then U.S. District Attorney Ann Davidson addressed the fact that the Seattle Police Department has a pattern and practice of not only biased policing but excessive use of force, is also being heard by Judge Robart, who will be hearing my habeas petition. and that I filed an amicus brief last year before Judge Robart, including one of my federal lawsuits, to inform Judge Robart, or the Robart Court, that it appears that the Department of Justice and the City Attorney's Office for the City of Seattle have been playing footsie and hiding from the Robart Court that the practice of excessive use of force and biased policing
Alright,
is
so
ongoing.
Spencer, I'm really sorry to cut you off, but
That's fine.
we just don't have the ability to do all of that. It will allow you to have the ability to be fully heard.
And
At this point, we really.
I have one more objection, Your Honor.
Okay, if we can keep it like this short, Mr. Benson, we're taking too long at this point.
Okay. We've got a violation of Brady v. Maryland because the prosecution has been withholding the evidence from the search warrant from me that was used to arrest me by the SWAT raiding my house on July 3rd. Within,
That's all I need to hear about, okay?
okay,
I'm
and
sorry,
then, and the exigency standard was not met.
Okay,
Okay,
I can have Mr. Lavin arraign you, and that will start the speedy trial clock, and then I'll let you know when we have the date set for you, if the motion can be fully heard. Mr. Lavin?
Can I serve him with the information?
Yes.
Mr. Manager, I'm gonna be top the information on the report item to this.
thank you.
Uh,
Can I, Your Honor, can I get the spelling of the prosecutor's name from our records? Or is it on here?
Don't know if it's on here, but it's Lavin is his last, Mr. Lavin.
Sir, is your term correct name Kurt Alden Benshew?
Yes.
Sir, Lisa Manning, prosecuting attorney for King County, in the name by the authority of the state of Washington, to accuse Kurt Alden Benshew of the following crimes, which are of the same or similar character, and which are based on the same conduct or a series of acts connected together constituting parts of a common scheme or intent. Felony stalking, attempting to elude pursuing police vehicle, attempting to elude a pursuing police vehicle, committed as follows. Count 1, felony stalking. That the defendant Kurt Alden Benshew of King County, Washington, at the time intervening from March 14, 2023, July 3rd, 2024, with lawful authority. 1A, did intentionally and repeatedly harass Jessica Ray Owen. B, did intentionally and repeatedly follow Jessica Ray Owen. And C, did intentionally contact, follow, track, monitor, or attempt to contact, follow, track, monitor Jessica Ray Owen. After being given actual notice that Jessica Ray Owen did not want to be contacted, followed, tracked, and monitored. And D, did knowingly without consent install or monitor an electronic tracking device or cause of the electronic tracking device installed based on routes to track the location of Jessica Ray Owen. And Jessica Ray Owen to A, suffered substantial emotional distress, or 2B, was placed in fear that the defendant intended to injure her or another person or property of Jessica Ray Owen for property of another person. And that substantial emotional distress and or fear was one that a reasonable person in the same situation would experience given the totality of the circumstances, or to C, that the defendant knowingly without consent installed a monitoring electronic tracking device or cause of electronic tracking device to be installed, placed, or used to track the location of the victim. The victim's knowledge of the tracking device would reasonably elicit substantial emotional distress. Here, 3A, the stalking violated any protective order protecting Jessica Ray Owen. Contrary to RCW 9A.46.110, Section 1, 5B, and against peace and dignity of the state of Washington. Further to allege the crime involves the following aggravating factor and accuse the defendant Kurt Alden Benshew committing and said offense involving stalking as defined in RCW 9A.46.110. 1, with insider sound of victims or the offender's minor child under 18 years. 2, the offense was part of an ongoing pattern of psychological, physical, or sexual abuse of the same victim or multiple victims, manifested by multiple incidents over a prolonged period of time. 3, that the defendant's conduct during the commission of said offense manifested deliberate cruelty or intimidation of the victim. This allegation is under the authority of RCW 9.94A.535 3H. Further to allege the crime involves the following aggravated factor: accused the defendant Kurt Alden Benshew committing said offense involving domestic violence as defined in RCW 10.99.020, and the offense was part of an ongoing pattern of psychological, physical, or sexual abuse of the same victim or multiple victims manifested by multiple incidents over a prolonged period of time. This allegation is under the authority of RCW 9.948.525 3HI, and further to accuse the defendant Kurt Alden Benshew at said time of committing the crime against an intimate partner as defined in RCW 10.99.020, which is a crime of domestic violence as defined in RCW 10.99.020. Count 2, attempting to elude a pursuing police vehicle. The defendant, Kurt Alden Benchuk, in King County, Washington, on or about April 27, 2023, while driving the motor vehicle, having been given a visual and audible signal by uniformed police officers to bring the vehicle to stop, willfully failed, refused to immediately stop, drove the vehicle in a reckless manner while attempting to elude a pursuing police vehicle that was equipped with lights and sirens, contrary to RCW 46.61.024, against the peace and dignity of the state of Washington. Count 3, attempting to elude a pursuing police vehicle. The defendant, Kurt Alden Benchuk, in King County, Washington, on or about August 23, 2023, while driving the motor vehicle, having been given a visual and audible signal by a uniformed police officer to bring the vehicle to a stop, willfully failed and refused to immediately stop and drove the vehicle in a reckless manner while attempting to elude the pursuing police vehicle that was equipped with lights and sirens, contrary to RCW 46.61.024, and against the peace and dignity of the state of Washington. I ask you to undertake this.
So that's a lot there. So, well, and admittedly stopped, right? But every state, allegedly, every state, my state has it, is you can pull over within a safe manner. As you can roll and put your hazard lights on and conduct moving on into a safe lit area and all that kind of stuff. So I'm assuming Washington has some form of same deal. All right. Did they in there put in there that he was following officers, which by the way is not illegal, and they're charging him for stalking, and yet recall the news that she was supposed to be at his house. Now that's saying domestic, that's a broad word, right? She did not live with him. So would that go in a category of domestic or not? I'm assuming it could because, if I go to like my brother's house or something, that would be kind of a domestic deal. So that's kind of broad, right? So there's a lot there, but it's kind of funny how she didn't live at the house. They didn't clearly establish the, what is that word? Domestic. And if they're talking about when they went because she was injured there, allegedly, well, then stalking would have to be dropped because she was at his house. All right, this is We the People News. Bye, y'all.